Catherine Amirfar.
And I'm Cal Raustiala.
And this is International Law Behind the Headlines, coming to you from
the American Society of International Law.
Hello, everyone, and welcome back to another episode of International Law Behind the Headlines. I'm Cal Raustiala, and I'm really happy to have on the podcast for this episode Samantha Rowe. Samantha is a partner at Debevoise and Plimpton in the London office, and we're going to talk about an issue that in some ways is a very longstanding issue, but one that's emerging rapidly onto the front pages, which is the question of deep seabed mining and how that intersects with the law of the sea. So Samantha, welcome to the podcast, and I really look forward to chatting with you about this topic.
Well, thanks so much for having me, and likewise.
Yeah, great. So as some of the listeners may know, we're recording this on May 16th. In the last couple of weeks, there's been increasing activity and then actually an executive order from the Trump administration trying to move forward a process of issuing, I guess, both regulations and actual go-ahead to begin mining the deep seabed. And that is a topic that was hotly contested in the negotiation of the UN Convention on the Law of the Sea, which maybe for the rest of this podcast we'll refer to as UNCLOS. I think that's a little shorter. And it's something that is still very much a controversial issue environmentally, economically, but for our purposes, legally. Is this actually lawful given the legal framework that exists? So I guess I'd like to start with that kind of big question, and maybe we could work back to the framework and what was created under UNCLOS. But we could just start there. So the ISA, the International Seabed Authority, based in Kingston, Jamaica, now 31 years old, I think, has stated more than once since this announcement that this is unlawful. This move by the United States is unlawful, and that effectively the ISA, the Seabed Authority, and UNCLOS kind of occupies the field with regard to deep seabed mining. So I guess I'd start with that. Is that accurate? How do you assess that? How might we think about that analytically?
Yeah, thanks for the question. And I think what we're talking about here is a sort of classic clash of the exercise of jurisdiction. So certainly under UNCLOS, and to put UNCLOS in context, it's an extremely broadly ratified international convention. It has 169 states parties, as well as the European Union. The United States, however, is the biggest outlier when it comes to UNCLOS. It hasn't signed or ratified the convention. Under UNCLOS, it is definitely the case that the International Seabed Authority has the jurisdiction to regulate and to issue permits in relation to deep sea mining in areas beyond national jurisdiction, so the high seas. What the US has done with the executive order is actually to resurrect a piece of legislation that is now 25 years old and that predates UNCLOS. So it was actually issued while UNCLOS was being negotiated. The US was heavily involved in the negotiation of UNCLOS, and you can actually tell from the legislation itself that it was fully intending to sign on to the convention when the legislation was issued. I will actually give it a name. It's got a not very catchy acronym, but it's called the Deep Seabed Hard Mineral Resources Act, the DSHMRA. I can't turn that into a word, I'm afraid.
That's okay.
So the DSHMRA, as I say, it was passed in 1980, and it sets itself up as an interim regime before UNCLOS comes into force for the United States to itself issue exploration and commercial recovery permits in relation to deep sea mining in the high seas. It's a really interesting piece of legislation, actually, because it doesn't purport to grant the United States sovereignty over the areas where the mining will take place. And it also contains quite strong statements about the need to respect other parties who are engaged in activities over the same areas. It has an idea about sort of reciprocal arrangements with other states in relation to deep sea mining over the same areas. But nevertheless, it remains in force and it grants the ability to the United States to issue these permits.
Great, great. So during that period of negotiation, which went on for 12 years, it was quite a long process. I know there was a lot of concern. Obviously, it's actually a super interesting negotiation process in which there were many things kind of being balanced and weighed, and the development of exclusive economic zones, and just so many different things happening. But the deep seabed mining question, which at that time I think was pretty notional as an actual practice, seemed to consume an inordinate amount of political attention. And I'm guessing that's one of the reasons the United States created this statutory framework, was because this was already kind of a hot button issue even then.
Yeah, I think that's right, and as I'm sure you know, Carl, so Part 11 is the part of UNCLOS that regulates deep sea mining and sets up the International Seabed Authority, and it was really Part 11 that was the sort of ultimate stumbling block as to why the United States didn't sign on to the convention in the 1980s and hasn't to this day. There is a reference within Part 11 to the sort of resources that you would find in the high seas being part of the common heritage of mankind. And there is a reference as well to the equitable sharing of benefits that result from deep sea mining. And the International Seabed Authority is actually charged with coming up with a mechanism for putting that equitable sharing of benefits into effect. So turning sort of a conceptual idea into a sort of hard profit sharing mechanism, if you will. And that certainly had a lot to do with the United States resistance to Part 11. And actually to this day, while the United States accepts that a lot of UNCLOS is customary international law, it has never accepted that Part 11 is part of customary international law. So that's obviously going to be a key argument for anybody trying to resist the notion that the United States is impeded by international law from unilaterally issuing its own permits in relation to deep sea mining.
Great. I want to circle back on that issue a little more intensely, because I think you're right. That does seem to be the key issue. Is it custom? Is the United States some kind of persistent objector, or somehow outside that framework? And then what's the interplay, which is, of course, a broad-ranging question of the interplay between treaty and custom in international law. But in terms of the kind of the U.S. concern, I guess, is it the case that the U.S. then and now was concerned about Part 11 because of because common heritage smacked of kind of socialism, that the Reagan administration, which was in charge in 1982 when this was all wrapped up, just thought, this seemed like big world government sharing of resources, just antithetical to the sort of free market principles that the Reagan administration in particular emphasized, or is there something more?
No, that's definitely part of it. And actually, interestingly, so obviously UNCLOS was adopted in the 1980s, so pre-fall of communism. Didn't actually enter into force until 1994, at which point we had an implementation agreement on Part 11. And part of the sort of reason why the global community was able to get to the point of signing on to and adopting UNCLOS and adopting the implementation agreement was, I think, the fall of communism, and the idea that while you still had references to these concepts in Part 11, they would perhaps take on a different meaning as we entered into the 1990s, and what people at the time thought was going to be kind of an end of history, right? That we were all actually kind of aligned around what all of this meant. But the fact is that to this day, this remains a contentious issue, and it remains part of the reason, and I'm sure we'll get onto this, why there is this deadlock within the International Seabed Authority and why it hasn't actually been able to move on to issuing exploitation permits yet. Part of the issues and dispute is that developing countries have quite a sort of strong they really stress the importance of the equitable benefit sharing and the common heritage of mankind principle. And they see that playing out in a certain way as we start to exploit these resources and commercialize them. While some other more industrialized nations and some of the corporations that are actually engaged in deep sea mining have a very different idea of what that should look like.
Yeah, that makes a lot of sense. I mean, on that topic, I know the Metals Company, which is a Canadian firm, I believe, is the one that's, aiming to get, the first set of permits and so forth. I'm assuming there's not a lot of companies that are actually ready to go with deep seabed mining. Is that right? Is it a big group? Is it a single company? What's sort of the actual state of play as of 2025?
Do you know what? That's actually an excellent question. And I honestly can't answer the question of who is literally ready to go if they were to get a permit tomorrow, who would be able to start exploiting these resources. Certainly the Metals Company has been the most vocal and has been pushing along with one of its sponsoring states, Nauru, to get the International Seabed Authority to move and start issuing exploitation permits. And actually it's the Metals Company with its US subsidiary is the first company to make applications under the US regime as well. So that part of the current sort of movement to get permits issued. Interestingly, the US actually did issue 4 exploration permits back in the 1980s, but again, this predated UNCLOS. But there are certainly more companies involved in the exploration and that actually have contracts with the International Seabed Authority and sponsoring states. I think it's actually 17 companies, and there's a total of 22 exploration agreements in place. So it's not just the Metals Company, but they've certainly, as I say, been the most vocal.
Yeah. And it's, of course, as an aside, kind of interesting at this moment where the US and Canada probably have the worst relationship that they've had since maybe the War of 1812. And yet this is going forward as a sort of joint venture. It's not obviously really a joint venture, but here's the US taking a move and a Canadian company, egging them on and working with them. But in any event, it does seem like the capacity to engage in deep seabed mining is something that's obviously going to be concentrated in the advanced industrial world. And many countries will not have that capacity for a number of reasons. And so the equitable sharing becomes very, very important because in a sort of open free-for-all system, they would not garner any of the benefits, or only indirectly through the market would they garner the benefits. I guess it might be worth, I want to get to the custom question, but just for listeners, the common understanding, and correct me if this is wrong, is that the reason that this is heating up right now really has to do with the growing needs for batteries, and that is driving that and certain kind of other rare mineral uses. But I think a lot of it is electric vehicle driven. Is that generally correct as to why we're so interested now?
It's a bit broader than that. So you're right. This is all about rare earth minerals, right? So nickel, cobalt, other rare earth elements. But they're essential for, yes, electric cars. It's batteries more broadly, wind turbines, but also other components of the energy transition. And what the proponents of deep sea mining would argue is that if we can get deep sea mining up and running, first of all, it actually may, this hasn't been proven yet, but this may be more environmentally sound than land-based mining. But it obviously also avoids a lot of the geopolitical issues that we're seeing at the moment with where the mining of rare earth minerals is happening and the countries and the companies that have heavily invested there and using those rare earth minerals for their own sort of transition-related development.
Yeah, it does seem like just at a kind of very high level of abstraction, the politics of this are kind of interesting because the Trump administration, on the one hand, isn't a huge fan of electric vehicles at the moment. They're rapidly scaling back tax incentives and so forth. On the other hand, they're very worried about China and Chinese control over a lot of rare earths and other minerals. And I will note that amongst the critics of the U.S. move, and those that have argued it's contrary to international law, is the Chinese government, outspoken, so not surprisingly. And so for the U.S. at this moment to be actively pursuing something that's very closely related to I think you called it the energy transition, which they don't seem to want an energy transition. They actually like the old way of energy. But of course, there are many other things going on, including antipathy towards the United Nations, frankly, which is something they've been pretty clear about.
Yeah, I think that's right. I think I would view this as being driven by the geopolitics and the supply chain issues that the US is facing as well. Yeah.
Right. Yeah. So let's turn to the issue of custom and whether in fact this move by the United States is contrary to customary international law, which of course rests on the premise that much of the UNCLOS framework, or maybe the common heritage principle itself, which I think was first articulated in the late 60s, and then sort of, became repeated in various resolutions and treaties and so forth, is that in fact a customary international law principle. So what are your thoughts on the status of either the status of either common heritage of mankind as a customary international law principle, or Part 11 specifically as custom? Maybe those are distinct.
Yeah, I'm going to take it backwards, and so Part 11. What it's going to be interesting to see is whether, the proponents of the idea that Part 11 is not custom and ergo the United States is entitled to take unilateral action in relation to deep sea mining, whether they are going to argue that it's just not custom full stop, or whether they're going to argue that the US has a persistent objector status in relation to Part 11. And what's interesting about that is, I think certainly if you look at the statements from the Reagan administration, they were very clear that the US was completely opposed to Part 11, and that, as I said earlier, that was why it wasn't signing on to the convention. But you then actually had Clinton in 1994 signing on to the agreement to implement Part 11, which, as I said, was what really unlocked UNCLOS. And he actually put both the convention and the implementation agreement before the Senate to get it ratified, and that has been there ever since. So you've had these sort of conflicting indications, I guess, from the United States about really how it perceives Part 11. But certainly I think that given the statements that the United States have made, given its role in sort of not getting UNCLOS to kind of full almost universal ratification, I think there certainly are arguments that it isn't custom. Certainly there are arguments that people will be able to take advantage of it if and when this ever gets before a dispute resolution body.
Do you think the better argument is that it isn't custom, or that the US is a persistent objector?
Ooh, that is an excellent question. I think if I were arguing the case, I would probably go the persistent objector route. It is a high bar, but given, how long Part 11 has otherwise been enforced, and it's otherwise pretty universal acceptance in the statements that have come out of the International Seabed Authority and the statements that other states have made, including, as you say, China, I think there's a decent argument to be made that it is otherwise custom.
Yeah, I guess I tend to agree with that. I mean, the interesting issue for me that I admit I've never really contemplated is persistent objector has always seemed like a doctrine that is, rarely much
Yeah,
discussed and rarely observed. But it
yeah,
also, by its very nature, assumes persistence.
yeah.
And what if, as we see here in this case, and as we might expect in the real world, differing governments over a long period of time will take differing positions on
Mhm.
an issue, and maybe even in a partisan way, as we tend to see around this. Though, it's funny, the issue of UNCLOS generally within the executive branch of the US is not so partisan. Both, consistently Republicans and Democrats have wanted or claimed to want to actually see it ratified by the Senate, for example. But
Mhm.
in any event, you can imagine a government switching and the position switching and then switching back and then switching back and so on and so forth. With that checkered pattern, can you claim to be a persistent objector?
Yeah.
Or by definition, can you not? And then is that inherently disadvantageous to democracies who might see more of that sort of swing? And even certain kinds of democracies. In any event, that's something I've never contemplated, and I'm not sure I've ever seen discussed. I'm sure it's in the literature somewhere.
No, I would tend to agree with you. And I think as well, the interesting thing about the US, I mean, as you say, it's not been a partisan issue, but actually, if you sort of look back over the history of it, it's different parts of the government saying different things as well, right? Because
Hmm.
you had Reagan saying hard no, Clinton saying yes, but then the Senate has actually consistently refused to ratify, whether you can sort of say that that's an objection as opposed to just a kind of passive failure to do something. There's an
Right.
argument that can be made, obviously. But you're right, it does seem like democratic states with democratic institutions that can disagree with each other, right? That there really may be a disadvantage there, possibly.
Yeah, yeah, absolutely. And it's not even the Senate that is really opposed to this or to UNCLOS generally. It's a very small group of Republican senators, effectively. It's not a particular, but
Yeah,
the way that the constitutional structure works, it doesn't take many
yeah,
to
yeah.
kind of bottle it up. So yeah, I guess that's an interesting persistent objector doctrinal question that if there are law students or others listening looking for a good topic, that might be one to
Mhm.
explore. But in any event, I agree with you that that's something the U.S. certainly could argue. Though it's not clear to me that they've made any actual legal claims at this point as a matter
No,
of public international law.
no. I don't believe they have, and you can sort of see why from a political viewpoint they would probably want to refrain from doing so, because if they are going to take the position that this is really something that they have the ability and the authority to do it, on their view of the world, international law is an irrelevance, right?
Yeah, yeah, I'm sure they don't want to lean into that, but
Yeah,
other administrations might take a different view. If this
yeah.
continues, obviously, in a few years, we might have a different president, a different kind of posture generally. Um, okay, what about so we talked about persistent objector. Let's do the other
Mm.
side a little more. What's the best case for why common heritage of mankind or Part 11 generally, you can define it as you wish, is in fact
Mm.
custom?
Yeah, I mean, I think you would sort of want to be tracing through the statements that have come out of the United Nations in particular, including actually statements that the United States itself has signed on to. And then, as I said earlier, I think if you sort of look at the discourse around this issue in particular, the number of states that have come out and said that what the United States is doing is a violation of international law, you could certainly sort of marshal that as well into a customary international law argument, right? The practice plus the opinio juris. So I think there are some good arguments to be made on that side as well. It's just not cut and dried either way.
Right, right. And do you think that those arguments have only come to fruition recently? In other words, if we went back to 1994 when the entry into force occurred, um, do you retrospectively, would you say even at that moment it was putatively custom, or is it something that's only accrued over the last decade or two through the actual practice of the treaty operating?
No, I think you would go back, as you said earlier, to the 1960s, I think, and really be trying to build the case based upon the statements made by the General Assembly in particular, and statements coming out of kind of various international bodies in support of the principle. So I don't think you would say that it's over the last 10 years and just the kind of operationalization. Is that a word? Like the operationalization.
It is now.
The principle through the actual kind of activities of the International Seabed Authority. I think you'd want to be saying that that is the sort of expression of a principle that has already been in existence for some decades.
Yeah. And of course, that principle extends well beyond the law of the sea context.
Exactly.
Picked up in many, many other treaties, resolutions, other legal acts of various kinds. So it's, I think the another interesting kind of legal question is you might argue the principle of common heritage of mankind has a customary law status, but then that's a high level of generality.
Totally.
What does that mean operationalized? In this context versus other, it often comes up in environmental treaties, for example, but the contexts are very different and the application is very different. Maybe we'd need a kind of bespoke argument in each case for how it sort of has evolved and cashes out in real situations.
Yeah, I agree with that. I mean, you and I sort of sat here discussing it at a high level is one thing, but kind of tracing this through in some sort of, litigation or dispute resolution context, getting from that principle to, what the United States is doing and the ultimate commercial recoveries that may or may not be made is another matter altogether.
Right. Okay, so I guess two other issues. I know we only have a little bit of time left, but one is, the ISA, as I understand it, the International Seabed Authority, has made a couple of statements critical of the U.S. move, arguing it's contrary to international law. Should they, in your view, be, issuing more fulsome legal analyses? What happens in this kind of situation for an international organization? Should they be doing more? What would you do if you were in their shoes?
Yeah, that's a really excellent question. I'm not sure that issuing a sort of more fulsome legal analysis just in the context of kind of a public statements is necessarily going to be helpful here. I think one thing that they absolutely need to consider doing, though, is figuring out a way to unlock the deadlock that we're currently seeing within the National Seabed Authority, right? And that is one of the, I think, kind of realpolitik impacts that we may see coming out of the recent executive orders from the United States, is that this will actually create an incentive within the International Seabed Authority to move forward. Like, they've been looking at regulations for the exploitation phase of deep sea mining since 2014. So it's been 11 years. And it got to the point where in 2021, actually, Nauru triggered what's called the 2-year rule. So if you put before the ISA an application sort of approval of a plan of work for exploitation, it triggers a sort of 2-year deadline for the ISA to issue the relevant regulations. That deadline was missed. There are currently draft regulations. I think the latest version was issued kind of late last year, and they are under discussion by the ISA now. But I think that they will see this as a matter of sort of new urgency, if you will. And so probably what they should be focused on is getting the work done and making sure that they actually have a workable regime in place, whatever it is that looks like, given the environmental concerns and others that people have raised.
Yeah. I think you're right that is likely to happen, or at least be pushed along. But these environmental concerns are not trivial, and of course they're not the only source of dissent between the various parties. So it'll be interesting to see how that plays out. I guess my other question is, let's assume in a couple of years there's actual mining, and now there are in fact minerals that have been brought up and refined and are for sale. Is there an issue the sale of those minerals on global markets because of this legal question about whether this was done contrary to international law? Is there any concern there? I've seen hints of that in some of the commentary, but I'm not sure how accurate that is.
Yeah, Cal, it's a really excellent point. And I think that this is the key area of commercial risk for companies and people that might be thinking about getting involved in this area. And I think actually the issue arises even before you get to the sale, right? Because a company that wants to get involved in deep sea mining needs financing and contractors and employees and a bunch of sort of ancillary services that they may run into issues obtaining if the third parties that they're trying to obtain them from are located within UNCLOS states, which are, members of the International Seabed Authority by default and subject to the provisions of UNCLOS. And the same applies, yes, you're absolutely right, when you get to the sale of whatever minerals are ultimately recovered. I think if we remain in this position where, as I said at the outset, we have this sort of clash of jurisdictions, there's a significant risk that needs to be sort of built into all of this, that you're not going to be able to get the financing you need, the services that you need, ultimately sell the minerals, because the parties to UNCLOS are going to put restrictions in place that prevent that from happening, and or there is just a sort of litigation risk around engaging with companies that are unilaterally involved in these activities.
Great. Well, thank you so much, Samantha. It's been a super interesting conversation, and this issue is obviously not going away. So we're really just getting going, and we don't even know. I mean, we'll find out if this mining, in fact, takes place, whether this is economically viable, how great this is. I mean, we know something at this point, but I think we'll learn a lot in the coming year or two. So I hope to have you back on the podcast at some point, and we can revisit some of these questions.
Absolutely. Thank you so much for having me.
Terrific. Take care.